Thank you, Mr. Chair. Continuing this important and timely dialogue, as the Supreme Court itself stated in Buckley v. Vallejo, quote, of almost equal concern as the danger of actual quid pro quo arrangements is the impact of the appearance of corruption, end quote. While this case dealt with financial contributions to elected government officials, the same logic applies to appointed judges. There's very serious concern of actual corruption in the absence of strictly enforced, rigorous ethical standards for our judges. But as the Buckley opinion made clear, there's also a serious concern that public trust in our highest court is damaged even by the appearance of impropriety, weakening the faith in our judicial institutions as a whole. Now, what's more, as a former federal judge and advisor to Vice President Mike Pence, speaking of Mike Ludwig here, he said in a statement to this committee, not some far left or whatever tagline some of my Republican colleagues would assign to Mr. Ludwig, he said, quote, this is emphatically not a partisan political issue and must not become one, end quote. And I agree. This is an issue of importance to all Americans. My first question is this, and I'll address it to Professor Frost. Can you explain the effect of when judges take actions that call into question their own ethical standards and how that impacts public faith in the courts?
Yes, it does so in two ways. First, when the law is binding on the justice and the justice does not follow it, I think it both undermines the integrity of the court system and also raises the question of whether the justice is following the law in all the other cases, because of course the justice is responsible for administering the law. And second, you made the point about the appearance of impropriety. So I think it's very important for judges and justices to be aware that even if they are doing nothing personally wrong, they're not trying to be bribed, if they create the appearance of that to others, that is a problem for the legitimacy of the judiciary.
So even the appearance of impropriety can be just as damaging as actual impropriety when it comes to the public trust in our court system.
Yes, and in fact, the code of conduct that applies only to the lower courts, and which the Supreme Court does not have to follow, specifically states that the appearance of impropriety is as much of a problem as actual impropriety.
So speaking of, according to federal statute, all judges are required to recuse themselves when they either have a financial interest in the outcome of a case or where there's otherwise a strong possibility that their decision could be biased. The Chief Justice, along with some of today's witnesses, argue that the Supreme Court cannot be subject to sensible, robust recusal rules because the Constitution demands that all 9 sit, and recusal would invite gamesmanship over which justices might hear a case. That's the argument anyway. I'll address this question to Mr. Payne. Is it accurate that 9 justices always make decisions together?
No, sometimes justices recuse and all 9 are not active on a case, but I also will point out the important point that recusal does not necessarily mean that the judge has to get off of a case if you have a procedure where the recusal disclosure, that is the rationale for not recusing, is made public, or the decision to recuse is made public. That also can provide what the public is looking for with transparency.
So I want to bring together the earlier topic in question of actual impropriety versus perceived impropriety, and now the dynamic of recusal. Back to Professor Frost. Bloomberg recently reported that Harlan Crow, the billionaire Republican donor that gave Justice Thomas hundreds of thousands of dollars worth of gifts and travel over 2 decades, had a financial interest in a case appealed to the Supreme Court in 2005, and that there's no indication that Justice Thomas recused himself from that matter. In your opinion, how does a situation such as this, with the absence of recusal, impact the public's faith and trust in the court system?
Yes, again, it's 2 problems. One, there's the possibility, or certainly the public would be reasonable to think that there might be bias when there's a financial interest by a justice in a case that justice is hearing. And second, there's the broader point of it's just disturbing to see any justice not follow a law that applies to them. They're responsible for administering the laws, and they should follow the laws that apply to them.
Thank you very much. Thank you, Mr. Chair.